Get ready for the dictation in 3, 2, 1, start. Furthermore, Section 8 of the Family Courts Act 1984 specifically excludes the jurisdiction of all other civil and criminal courts in relation to suits or proceedings for which jurisdiction has been vested in the family courts by Section 7 of the said Act. Section 8, which is reproduced herein below for the ready reference of this Honorable Court, would leave no manner of doubt that wherever family court have been established, they shall have exclusive jurisdiction over all matters covered by Section 7 of the said Act. Para. Exclusion of jurisdiction and pending proceedings where a family court has been established for any area, no district court or any subordinate civil court referred to in subsection 1 of section 7 shall in relation to such area have or exercise any jurisdiction in respect of any suit or proceeding of the nature referred to in the explanation to that subsection. Magistrate shall in relation to such area have or exercise any jurisdiction or power under Chapter 9 of the Code of Criminal Procedure 1973 2 of 1974. Every suit or proceeding of the nature referred to in the explanation of subsection 1 of section 7 and every proceeding under Chapter 9 of the Code of Criminal Procedure 1973 2 of 1974, which is pending immediately before the establishment of such family court before any district court or subordinate court referred to in that subsection, or as the case may be, before any magistrate under the said court, and which could have been required to be instituted or taken before or by such family court if before the date on which such suit or proceeding was instituted or taken, this act had come into force and such family court had been established, shall stand transferred to such family court on the date on which it is established. That wide Section 13 of the Family Courts Act 1984, the fundamental right to practice any profession for an advocate in form of making legal representation has been specifically been denied. Section 13 reads as under, notwithstanding anything contained in any law, no party to a suit or proceeding before a family court shall be entitled as of right to be represented by a legal practitioner. Provided that if the family court considers it necessary in the interest of justice, it may seek the assistance of a legal expert as amicus curiae. Para. That the Honorable Supreme Court in the case of Lingappa Appealwar versus State of Maharashtra and another reported in AIR 1985 SC 389 had an occasion to deal with the constitutional validity of Section 9A of the Maharashtra Restoration of Lands to Scheduled Tribes Act 1975, which was couched in similar terms as Section 13 of the said Act, beginning with the notwithstanding clause depriving the pleader's right to appear on behalf of parties in any proceedings under the Act before the Collector, Commissioner, or the Maharashtra Revenue Tribunal. Stop. It was held as under that contention that an advocate enrolled under the Advocates Act 1961 has an absolute right to practice before all courts and tribunals can hardly be accepted. Stop. Such a right is no doubt conferred by Section 30 of the Advocates Act. Stop. But unfortunately for legal profession, Section 30 has not been brought into force so far, though the Act has been on the statute book for the last 22 years. Stop. There is very little that we can do in the matter, and it is for the bar to take it up elsewhere. Stop. A person enrolled as an advocate under the Advocates Act is not ipso facto entitled to a right of audience in all courts unless Section 30 of that Act is first brought into force. Stop. That is a matter which is still regulated by different statutes, and the extent of the right to practice must depend on the terms of those statutes. Stop. The right of an advocate brought on the rolls to practice it, therefore, just what is conferred on him by Section 14(1) A, B, and C of the Bar Councils Act 1926. The aforesaid observations made by the Honorable Supreme Court would demonstrate that non-enforcement of Section 30 of the Advocates Act 1961 was perceived by the Honorable Supreme Court as the only impediment on the absolute right of the advocates to practice before all courts and tribunals. Stop. Thank you.